In today's video, I'm not covering the following three issues. First, what is Trump's Executive Order 14160? Second, what is Supreme Court's decision on Trump's Executive Order 14160? And third, what is the impact on birthright citizenship? Okay, so first let's have an overview of the recent Supreme Court decision. This is a decision made by Supreme Court on June 22nd, 2025 on the case Trump sue CASA. So CASA is an organization joining this lawsuit. This case is often framed as Supreme Court shakes birthright citizenship. Okay, so let's see how it shakes birthright citizenship. Well, before that, let me refresh your memory by what is Executive Order 14160. It is an executive order signed by President Trump on January 20th, 2025. That is the first day of Trump administration. It directs federal agencies to redefine the scope of 14th Amendment's citizenship clause. And it says only individuals born to at least one U.S. citizen, lawful permanent resident, that is green card holder, or other person lawfully admitted for permanent residence or naturalization shall be considered subject to the jurisdiction of the United States for the purpose of birthright citizenship. So in other words, it says that only in the situation that one of the parents is green card holder or U.S. citizen, then the baby born on the land of the United States can get U.S. citizenship. But as you know, before that, no matter who your parents are, anybody born on the land of the United States will get U.S. citizenship. Okay, so let's see what are the group of people that will be excluded by Executive Order 14160. First of all, children born to undocumented immigrants. And second, children born to tourists. That is, as you know, there are tens of thousands of women fly to the United States every year just to give birth here, to have their baby get U.S. citizenship, right? So these people will also be excluded under Executive Order 14160. And third, it is children born to international students, that is, people with F1 visa. Fourth, it will exclude children born to temporary workers, that is H-1B visa holders. As you know, most of the IT programmers, software engineers in big techs are H-1B holders. And finally, it's a catch-up clause that would exclude all the children of individuals on any non-immigrant visa, unless they are on the path to permanent resident. Okay, so it actually excludes a pretty broad group of people. Then let's see what is the Supreme Court's decision on Trump's executive order. Here are some key highlights. The Supreme Court wrote 623 that lower federal courts do not have the authority to issue universal or nationwide injunctions that block a federal policy beyond the parties involved in the lawsuit. It's kind of interesting but confused and weird decision, right? It does not touch the constitutionality of Executive Order 14160, but just redefine the scope of authority of lower federal courts. And it also gives 30-day grace period for the lower courts to reconsider whether they will limit the injunctions only to protect those who join the case as named plaintiffs. So it means 30 days later, on July 27th, 2025, there will be a clear decision. But actually, what I would like to share with you is that for immigrants who like to give birth to their babies on the land of the United States, it's actually clear enough for you to make decision for your family plan. Why that? So from the Supreme Court's decision itself, it only restricts the lower federal court's rights, but it actually makes Trump's executive order much easier to be enforced. There are in total 94 federal district courts in the United States, and there are in total around 700 judges in all of those federal district courts. And before the Supreme Court's decision on June 27, 2025, any of those 94 federal district courts can issue an injunction to block the enforcement of the president's executive order, which means that if the president wants to enforce an executive order, he needs to make all of the 94 federal district courts good with it, or at least more than half of the 700 district court judges agree with his executive order. So that is pretty hard or even mission impossible. That is also the reason why the prior presidents seldom sign any executive order, or even if they sign some executive order, the content of the executive order is pretty mild, so that none of the 94 federal district courts would say no. None of them would issue an injunction to block the enforcement of the president's executive order. Of course, the prior presidents have been trying to change the federal district court's authority, but none of the 5 prior presidents has won on that. And this time, Trump wins on that. And Trump wins even more on birthright citizenship. And just like Justice Sotomayor said that, if the authority of the lower federal courts are restricted, then no rights are safe. Today is birthright citizenship, and tomorrow might be gun ownership. Let's also take a look at the different opinions of the 9 judges on Supreme Court. So the majority opinion authored by 6 judges, it's just like the final decision. They say that lower federal courts lack the authority under the 1789 Judiciary Act to issue universal injunctions. While the dissenting opinion supported by 3 judges, Justice Sotomayor said that majority ignores the unconstitutionality of Executive Order 14160 and undercuts judiciary's ability to protect constitutional rights. And Justice Jackson even says that the ruling enables executive overreach, allowing unconstitutional actions to continue unless every impacted person file a lawsuit. Based on the current decision, it is restricting the lower federal court's authority only to the states where they are located, and even more only to those plaintiffs who file a lawsuit. Of course, for that part, the Supreme Court gave a 30-day grace period for the lower court to make a decision. But if that is true, it means that if you are an immigrant, if you are planning to give birth to a baby on the land of the United States in order to get U.S. citizenship for the baby, then you must join in the lawsuit against Trump's executive order. That is actually a pretty harsh requirement and almost mission impossible for each of the parents to join in a lawsuit against Trump, right? Justice Barrett, holding majority opinion, argued back that Jackson's view fostered an imperial judiciary. Yes, it makes kind of sense, because before the Supreme Court's decision on June 27, 2025, any of the federal district courts can issue an injunction to block the president's executive order, which would give superpower to the lower federal courts. But as you may know, if we wait until the Supreme Court to make decision on the president's executive order, then that'll be too late. A case would go to federal district court first and then go to court appeal, and finally would reach to Supreme Court. The whole process would take at least 2 to 3 years or even 10 years. The president can sign an executive order in 1 day, but if people wait until 2 or 3 years or even 10 years later to block that, then that is meaningless. And if based on the current decision, only the states where the federal district courts are located can be protected by the injunctions, then it means all of the 94 federal district courts need to issue an injunction to protect people in their jurisdiction, and even more, only to those people in their jurisdiction and joining the lawsuit, which would be pretty costly for those people who are impacted. So that is also the reason why Justice Jackson warns that this current decision would actually create an imperial executive. So from the different opinions of the 9 judges of the Supreme Court, we can see that how polarized people's opinions are on this topic. And some people even say that this is a battle of ideology, not judiciary. Well, after the analysis of the Supreme Court's decision, let's go back to the core issue here. What is birthright citizenship, and whose baby will finally get birthright citizenship? Birthright citizenship is in the 14th Amendment of Constitution. It says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Well, we need to know some of the context in order to better understand birthright citizenship. The 14th Amendment was actually passed in the aftermath of the U.S. Civil War. and its background is deeply tied to slavery. It's used to protect the enslaved people. There is a precedent in case Dred Scott Sue Sanford in 1857. It wrote that black people could never be U.S. citizens, even if they are born in the U.S. So 14th Amendment says that we need to protect the enslaved black people to help them get citizenship. And then in 1898, in the case of U.S. Sue Wong Kim Ark, the Supreme Court also wrote that children born in the United States to non-citizenship Chinese parents are U.S. citizens, which is kind of an enlargement of 14th Amendment based on the historic background at that time. Wong Kim Ark, his parents are laborers like many Chinese immigrants during the late 19th century, working on railroad constructions and other labor work. The rationale of the Supreme Court in this case is that even if the parents of Wong Kim Ark are not U.S. citizens, they are legally residing on the land of the United States and they are contributing to the country for many years. Under that situation, it makes more sense to give their children U.S. citizenship. We will find that no matter for the purpose to protect enslaved people or the purpose to protect Chinese laborers, they are all people legally living on the land of the United States who are contributing to the country a lot. That explains the modern controversy for 14th Amendment birthright citizenship. Recent years, the birthright citizenship has been used to undocumented immigrants who entering the land of the United States illegally but give birth in the United States. There are also another group of people called birth tourism who are pregnant foreign women coming to the United States just for the purpose of giving birth on the land of the United States to get U.S. citizenship. So based on that, you will find that it actually makes kind of sense to restrict the birthright citizenship. But the current executive order is also overreaching if they are also excluding the international students under F1 visa or temporary workers under H1B visa. Because they are also people legally enter the United States, legally residing here, and contributing to the country. So let's see if after 30 days, the lower federal courts do decide that the injunctions would only protect plaintiffs joining the lawsuit against the president's executive order, what will happen? Until now, there are 4 states joining this lawsuit, including Maryland, Washington, Massachusetts, and New Hampshire. Of course, as we can imagine, the lower federal courts who issue injunctions to block the enforcement of the executive order are highly likely not to narrow the injunctions only to the named plaintiffs. So it means that it's highly likely that the birthright citizenship would only be split by states instead of by people who joined in the lawsuit and people who did not join in the lawsuit. However, Executive Order 14160 is just the beginning. Now the ruling has reshaped the injunction powers. So future administrations, not just Trump's administration, may be even more aggressive in pushing controversial policies. Then it would not be a check and balance between judiciary and executive, but more of a battle of ideology.